My name is Wojciech Wiewiorowski. I'm the European Data Protection Supervisor, and it's my pleasure to welcome you at the last panel which is going on in this room today, which is organized by the European Data Protection Supervisor, and which will be also followed by the small cocktail organized by our institution. So the same rule as it was yesterday. So before we stop to discuss here, the alcohol will not be open in the village. So you can easily stay here to the end of the discussion. We will try to do it smoothly and what most important, interestingly. Well, surprisingly, the subject of this discussion during this panel is artificial intelligence. That's quite a surprising thing in the program of this conference. So we have to find the aspects that we were not that much discussing so far, although there was already one panel about the governance, which was going on yesterday in the afternoon. But this time, talking about AI governance and the innovative approaches to that, we would like to look at this from both data protection authorities' perspective and the public authorities' perspective, who are dealing with the data and who are trying to see how the data can be used and how can it be also misused. But we are not going to talk about the philosophy, and we are not going to talk about the general principles. We will try to talk about the learning exercises that have been already done in several countries, both with the introduction of the artificially intelligent systems, although, as you precisely know, there is no artificial intelligence in the world at the moment. And what we call artificial intelligence, as it was said in the panel an hour and a half ago, is most probably everything which is sophisticated technology and is not a blockchain, which was a buzzword last year. So what is then our approach? We would like to talk about the forms of the governance which are necessary for the artificial intelligence applications and the rules and the roles of the data protection authorities that are played in the supervision of that. And this panel will explore the challenges for the data protection supervisors, data protection authorities, and the other public authorities that are supervising the field. We will talk about regulatory sandboxes. Is it the way to deal with it? What about the ethical field? What about the data lakes? Is it if the data lakes for research and training are the way forward as far as algorithmic systems are concerned? And we will also touch the problem of the presumption of innocence, due process, non-discriminatory treatment, and other difficulties and risks that we have to anticipate in our work. The EDPS tries to facilitate this discussion, and the way to that was the preparation that we did last week. And this Tuesday, we have organized the World Café on this subject. World Café, which is the very interactive and participative format to do the brainstorming, where we invited the participants from very different groups. We had 40 participants from DPAs, from NGOs, from academia, from EU institutions and bodies, from the private sector, and they came out with two main groups of the questions that they want to ask, and that will be building our questions to the panelists after their presentation. First of all, about the expertise and how we can act as experts in this field. And second, about the expectations for the DPAs on collaborative work with the stakeholders, which we, EDPS, try to do through the Digital Clearinghouse or the Hague Forum. And for this reason, we invited 4 representatives of the 4 things which are right now going on and which we can assess the effectiveness of. First of all, we have the representative of the ICO, the British UK Data Protection Authority, and we will discuss Auditing Framework. We will also talk about AI systems and categorizations of that with the German Data Ethics Commission, or representative of it. But first of all, one of the IT commissioner, IT specialist, who is the Data Protection Authority in her jurisdiction. Then we will have the representative of the Finnish authorities that are dealing with the secondary use of social health and socio-economic data. And finally, the EU representative, the representative of the DG Justice, dealing with the plans of the EU on how to approach the subject. So we have 4 speakers. Ruben Binz. Ruben is the research fellow in the ICO. He is in charge of developing the framework designed to audit the algorithms. He is the computer scientist from the University of Oxford, and at the same time, he got the bachelor's degree and master in philosophy in Cambridge University, and the computer science degree in Faculty of Business and Law of the University of Southampton. We have with us Marit Hanson. As I said, Marit Hanson is the data protection authority in Schleswig-Holstein, in one of the lands of Germany, and involved in the data protection field for a long time, but not as a lawyer, but as an IT specialist. So she was really pivotal to all the actions which were trying to create the field to discuss for the data protection authorities from the technical point of view. We will have with us the representative of the Finnish Ministry of Health, Joni Komulainen. Joni have been involved both in the private sector and then in different kind of public bodies, dealing with the ICT, dealing with the use of the data and use of what is the most important for us, e-health data, welfare information, the information which is stored in the public registers and at the players. And finally, Olivier Micol from DG Justice. Olivier has been working in the Commission already for 24 years, I guess, and is the head of the Data Protection Unit within the Director General for Justice, Consumers and European Commission, of the European Commission, and he is going to tell us about the ethical aspects of AI and how the Commission wants to approach the problem of the fundamental rights in these systems, which are still the future, but the future which we already can see in practice. So, Ruben, let's start.
Thanks. Can you hear me all right? Good. Okay, so yes, thank you very much for that introduction. I'll go through a few of the things that we're doing at the Information Commissioner's Office that have to do with AI. So one of the things that you may have seen recently is we produced some guidance on explaining AI-driven decisions to data subjects. That's the Explain project. What I've been working on is an auditing framework for AI. And what we mean by that is, as a data protection authority, we, from time to time, need to assess data controllers which are using AI. And so my task has been to equip our teams that do investigations, that do DPIA assessments, and other activities, so that they understand what AI is, what kinds of questions we need to ask, what kinds of data protection risks we need to be wary of when we're auditing these systems. But as well as equipping us internally to do this kind of work, we thought it'd be useful to engage with a wide range of different stakeholders, so industry, government, civil society and others, to get their input on our framework so that we can make sure that we're addressing all of the risks, that we're being realistic about the things that we expect. So I'll talk a bit more about that in detail, but 2 other things that we're working on. We have a regulatory sandbox, which includes a range of different projects that are in some way innovative, that involve using data in new ways. And the participants in the sandbox have come to us at the beginning of their projects, and they have challenges in terms of how do they apply data protection to the new kinds of ways that they're using data. And a few of those projects have involved AI, so I'll go into some of those as well. And then finally, we have a working group with other regulators, including the financial services regulator, competition regulator, where we discuss artificial intelligence and how it crosses different regulatory perimeters and common issues that we have and challenges that we have in regulating AI. So to go into a bit of detail on the auditing framework, one of the challenges I think we've found is that we really, in order to be effective, we need to engage at least 3 different audiences. So one audience is the data protection officer. This is the audience that we're used to talking to. They understand data protection law, they understand how to apply it in the context that they're working in, but they may not understand how AI works, and they may not understand the risks that apply in using AI in their particular context. Then there are the compliance and risk management people, and they have to contend with not just data protection risk, but operational risk, business risk, reputational risk, and they take a more holistic view of AI, but they're there to ensure that things get done in practice. So policies are actually enforced, people check each other's work, escalate when things go wrong. And then there are the engineers, and in fact, when it comes to AI, they may even be quite different kinds of engineers. So if you're used to software engineers working in certain ways with checking each other's code, having version control, with AI, the engineers may come from different backgrounds. They may have a background in statistics or physics or data science, and they may not be used to engineering systems in the same way that software engineers are. So there's a whole other element to that, which is not just data protection by design that would apply to any kind of software, but in the particular context of AI and machine learning. We've also been doing work to engage other stakeholders as well. So as part of the Explain guidance, we had a series of roundtables and a series of citizens' juries, where we selected members of the population that represent the whole population. And we got them together for a week, and we gave them lots of information and expert lectures and interactive exercises to do with AI, to help them understand AI, and to help them think through the trade-offs that might be involved in where there's challenges of interpretability and accuracy. One of the things that we've been looking at in that context is to what extent do privacy-enhancing technologies have a role to play in making sure that the use of AI serves data protection interests? So it's not just about ensuring that there's minimal data, but it's also building your systems in such a way that you can, in some cases, not even process data to begin with. Another challenge we've addressed is the fact that most AI is not built in-house. So organizations don't have the data, the infrastructure, the machine learning engineers to build models using their own data and using their own infrastructure. So what they do is they outsource. They maybe have machine learning as a service, where the model is built by another party, and they query that model via the cloud and get predictions back. And we think some of the challenges there are around where you have difficult controller-processor relationships, you have difficulty demarcating responsibilities. So those are some of the challenges we've tried to address in the framework. Finally, just to go into some detail on the sandbox, the aim with the sandbox is really to ensure that when organizations want to do innovative stuff, data protection isn't a barrier. Now, there are some kinds of innovation which will not be data protection compliant, and those are not the ones we want. So our aim is to guide them towards achieving what the novel use of data is, but without contravening data protection. So one of the things we've learned there is that it really is possible to do exploratory data science without just collecting all of the data. So it's possible to break down the development and deployment of systems into discrete stages, and at each stage reconsider whether you really need that data. So that's one of the lessons we've had. And finally, another lesson we've had is it's a complex supply chain with AI. And in many cases, the people who are using the AI will have difficult relationships with the providers where they have to check certain things for compliance and they're not in a position necessarily to check them themselves. So those are some of the challenges we've discovered in the sandbox. I think I'll end there so I don't go over time. Great.
And could you just supplement it with saying if the sandboxes are used for innovative technologies that are just appearing on also those that are already on the market, but somebody wants to use them, use the sandbox as the checkpoint for the things which they already have? And what would happen if you find this innovative technology anyway in compliant with the data protection rules?
So I think the way we've tried to manage that is by accepting participants in the sandbox before they've deployed a system. So when they're thinking about if we wanted to do this, how would we do it in a compliant way? And also by narrowly scoping the scope of the project to be the particular processing that will be involved as part of that project, and not to go into a wider range of processes that the organization might be undertaking outside of the project.
Okay, we will come back to the questions in a while. Marit, could you present your experiences in this field?
Okay, thank you so much. I think it will work that way. So I'd like to give some insight into what has been happening in Germany last year, because our federal system with 16 Länder, we agreed to have also an initiative, a task force on artificial intelligence to bring together all the different ideas of the data protection authorities in Germany. And also what we did is something in the area of information, freedom of information commissioners, because most of us have two hats, so only the ones with the data protection and the ones with the freedom of information tasks. And this is the thing in the middle, the transparency of public administration when using algorithms. This is something where we did not only address those algorithmic systems that are relying on personal data or have an output as a decision or decision proposal related to human beings, but it could also be something like the statics of a bridge. Does it work or not? That something has to be checkable even if it's outside the system of data protection. But the same instruments can be used for that. And this is now from 2019 where we proposed that on the international level for the information commissioners. I think it's still under in some phase where it's still debated. I'm not totally sure. I couldn't find out in the morning. But we want to make this point. We have to have more transparency and explainability. And the last thing here is from the Data Ethics Commission. I will dive into that in a minute. But first, what did we do with the data protection authorities? First, we had a meeting at a castle which is very famous in Germany, Hambach. This is the Hambacher Erklärung meeting. It's something where the freedom of press a few hundred years ago was celebrated very much, and now we did something similar, freedom of or guarantee of data protection requirements for artificial intelligence, and there are 7 main requirements, so a very short paper. But then what we did is mainly with the people more in the technical field, so the requirements came from all the data protection commissioners, where we only have 2 with technical background and the most have the legal background. But the publication here, you see only a few slides here on so many criteria of the measures that should be taken during development and operation. So that, again, something which has been developed already in a way which is data protection compliant, data protection by design, or designed in a way that it's checkable, easier checkable for those who are the controllers, for those who are the processors, and of course also for the data protection authorities or for the courts in the last instances, that this makes sense to think already ahead. And we have, I think, 5 pages on criteria and some explaining text. Unfortunately, this has been passed only in November, meaning it has not been translated as far as I know, but it will be translated. And you see here the different phases we had on what about the training data, what about the data which goes into the training data, what about the artificial intelligence and the validation, that there are different phases and different ways to influence that the data protection compliance is better off or guaranteed, even guaranteed, in the different phases. Which also means that sometimes different stakeholders are addressed, like the software engineers or other engineers, also data analysts or statistics people. So there's a full bunch of disciplines that makes sense to be part of the system, but sometimes if you're the controller, you only want to take the system and everything is all right, and you won't dig into what about the training data, or because you think it's already configured in the way you need it. But very often this is not the case, and sometimes you will be asked whether this has been trained in the right way, whether there can be a bias. Usually it's so hard to have training data without a bias. You often don't see the bias. And if discrimination happens, how to retrain or rescue that you still are able to use a system in a fair way and don't have to redo everything again. And now the last thing we did was with the Data Ethics Commission. We heard here already a few speakers mentioning that. The Data Ethics Commission was working from September 2018 for 1 year to present some recommendations for fair design or fair development towards an information and digitized society. And this is one figure here in the, since yesterday the full report is available in English, from the report. And we had a criticality pyramid to distinguish, do we need regulation or not? And of course also the provision of the services operation, but also the development of the services can or has to be influenced because of the criticality. A pyramid always looks nice because there's a very tiny area on the top, which is very high risk area, and the green thing in the bottom and something in between. We don't have numbers, but we discuss very many scenarios, and it seems plausible to have this idea of, and we defined 5 different levels of criticality. Let's have a small look here. And what we also needed to discuss, it's not only the algorithm, it's not only the code, it's not only something where we see input, processing, output. Usually it's a full system. Who sometimes from the audience gets spam emails? Sometimes. So few, or I think everybody. Okay, and who is using spam filtering systems? Again, who can explain how the specific spam filtering system works? Oh, 2. Okay, so many people are using, 3, 4, okay, I agree. Many people are using a system which they probably don't understand. And even if those 4 people explain how it works, probably works, then probably they won't get it, or it does not matter so much, because you can guarantee or make sure that the emails are not lost because they are put into a spam folder. And for my office, it's clear we must not suppress emails. This is not allowed. So still, we cannot work without a spam filter. Meaning we have a policy that we have to regularly check the spam folder. So an algorithmic system, even if we cannot fully understand, or not everybody can fully understand how this system component of the algorithm works, and what about the training data and so on, we still can use it because it's usually low risk, because the remedies are already part of the system. And if we then look into the very top of the pyramid, we have the thing where from the Data Ethics Commission, we agree there may or must be a total ban of some system. We discussed very much, are there many cases? No, we didn't find so many cases. But in automatic killing, we all had the feeling this should be banned, that it's not good to put now the burden on some algorithms or algorithmic engineers saying this is now something where algorithmic systems should work. You may have a different answer on that, but we think there may be very few cases, but where we really don't want to see any processing. And now the interesting part is, of course, in the middle. And only, I think it's not so much new in the requirements, but of course for each each case or each category, it will have to be discussed where does it belong to. For example, if we look at German nuclear power plants, there usually is a steady, always-on monitoring with some ministry, so a supervisory institution, because if something happens, there has to be a very quick reaction. This may be part of some algorithmic systems as well, that there has to be a steady line to some supervision, not necessarily the DPAs, because very often it's not a data protection problem, and I don't think this is a good role we should come into, but something where the monitoring can happen in real time. Level 4. Level 3, we have a clear system that not every car may be on the road. You have to be examined, and there's a TÜV system. So ex ante, it has to be clear that this car is all right, and every second year at least, it has to be checked and re-evaluated. Again, something we can borrow for some middle critical algorithms. And the last level, the first next one for the regulation, level 2, would be something where it's about disclosing more information, sometimes only if there are supervisory authorities. Sometimes it may be something where the public has to know, or where the controllers very much will ask for that, because otherwise it won't be able to minimize the risk as much as necessary. And here it could be something like a scoring system where already we need some more insight, even if there are business secrets. This cannot be an excuse to say, no, I won't reveal anything. It's not a green, low-risk system. We have to have mechanisms that at least some experts can access that. So this is our work, which was done, and I'm looking forward in having these slides online with then the English pictures, where you can see the translated version also of the German data protection commissioners. Thank you.
Thank you very much, and let me ask if the outcomes of the ethics committee are useful in the normal activity of your supervisory authority, or you just treat it as a part of the work for the future, or is it something that you can use already at the moment?
It's something where it's the next step, or the second next step. Meaning we can already use some of this stuff, but mainly because we want to think ahead. We want to make sure that we are on the right track, and especially if we give advice to parliamentarians or to lawmakers, it has to be part of our debate, I think, to be aware of what is happening, also on non-personal data, also with the idea of freedom of information, and therefore, yes. But if I say there are 1,000 complaints and I have to look into the Data Ethics Commission report, no, this is of course not happening. The complaints are really very the bottom line of our work, and there's clear guidance. The GDPR, by the way, is again acknowledged by the Data Ethics Commission, so nobody wanted to remove this reform. But of course there can be something where we think that it may be a little bit more detailed, or there can be some improvement, but especially the main idea is, what do we have to do for a fair society where even if you do data protection by design, and we are not there, even if you do that, that still we have to look ahead that it's still fair, because there might be something where data protection has won, everybody is anonymizing data and so on, but still there may be discrimination or also some unfair cases or outcomes which may raise difficulties for national or companies or societal sovereignty issues. So something where we usually don't have this as a main task, but if we don't think ahead, then the solutions may not be the best ones for our society.
Thank you very much. So let's move now to Finland, and let's see how it looks like from the Finnish perspective in the e-health system, in the welfare.
Good evening on my behalf. Yesterday I actually gave the same presentations. I had 2 slides. Today I have 26 slides. I try to be brief. I just want to explain that In Finland, and I'm sure that in many other countries, we don't have regulations regarding AI, especially in the sector of social and healthcare services. When we're providing social and healthcare services, AI is used every day, more and more. Automatic decision making is done all the time when we are actually giving benefits to people, for example. But at the moment, we don't have regulation regarding that, at least not in Finland. We have tried to have regulations regarding that during the last parliament, but we failed. Was it 3 or 4 times in a row? And now all the ministries are working together to have regulations on that area. What we actually have is a regulation using AI in secondary use purposes, which is sort of funny that we don't have the regulations in the primary use purposes. Yesterday I was explaining that in Europe we are talking about forming some sort of European health data space, and I said, we have it in Finland already, and we don't just have a health data space, we have social affairs data as well, and benefit data. And how did it happen? You need lots of things. So the challenge when we were drafting the Finnish legislation on the secondary use of social and healthcare data was sort of how to securely utilize the data that we already have. And I'm talking about health data, social affairs data, well-being data, benefit data, and for many different purposes, common purposes that we already know are scientific research and statistics, but the development and innovation activities where we're actually enabling to use AI for the first time. And of course, you can see many other secondary use purposes that we have enabled with this legislation. Yeah, you need to have lots of high quality data and have the data gathered for a long time, what we have done in Finland and in many northern countries as well, like Norway, Denmark, and so on. And in the previous panel was mentioned, you need to have, in order to make it easier, you don't need to have it, but make it easier, unique ID number, so you can interlink the information that's gathered, like from myself, Joni Komolainen. Basically, everything relating to Joni Komolainen, if you have the ID number, you can find every single information that there is about me. But of course, in order to use that information, you need to have a legal basis for that. So, in the old days, how did it used to happen? If you wanted to use social and healthcare data for secondary use purposes, you had to contact each and every data controller or an authority separately. After the reform, you can just contact one authority, which is a permit authority called FinData. Just one authority, and that's it. And you can get the data from all those various different data controllers and authorities. So FinData is the one-stop shop for secondary use of social and healthcare data. And what we have enabled is safe and secure environments, safe and secure permit portals, safe and secure processing of data. So after the reform, there's one permit authority, and the data is handled in conformity with GDPR. There will be no need for separate permits, just one permit from one authority. And you can actually send the application once we have enabled it technically from Europe. So you can send your own application, or your organization can send the application to FinData. Or it doesn't have to be from Europe, it could be from America and the rest of Europe. But the FinData is the authority that makes the decision if you get the data and what sort of data you will get. So we have enabled wider use of Secondary use purposes, like I said, electronic permit portal, safe and secure environments. We have advisory services, so you can contact the data controllers or the permit authority, and they will tell you what sort of data they have, would it fulfill your purposes, and how much the data would actually cost. So, from one place, Fin data, and what data you can get. We have sort of holistic approach. Small print, you probably can't see it, but sort of basic idea is that it's not just health data. It's sort of data that's interlinked to health, social affairs, socio-economic data as well. So from all those different authorities, you can get data. Not all the data, but data that's related to health and social affairs. So most of the time, the centralized data permit authority is responsible for giving permits, especially if you want to have information from all the different data controllers, private sector, and so-called Kanta services, where we have social affairs and health data. And of course, you can contact the separate data controllers and authorities if you want to wait for a long, long time. So the big change actually was that instead of contacting all the different data controllers, you get the data from one authority within short deadlines, which is 3 months' time, which is short. So here's the big picture of what sort of data is available below. So lots of different kinds of data is available. You have the data permit authority. In the future, we will enable separate service operator, which will handle more sort of technical things, anonymization, pseudonymization, gathering of the data. Up there, you have the legal purposes, and we are more interested now about development innovation. We have enabled AI. Here's another big picture of the same thing, what sort of data is available through one central authority. So lots of different data that we have gathered since the 50s. One permit, one authority, strict deadlines, and data controllers have the advisory services and descriptions of the data. So you can have the conversations what sort of data you need, fulfill your purposes, and how much it will cost. Basically, you will get anonymized data, pseudonyms, or identifiable data only in safe and secure environments, which are audited, certified environments where you can't get the data out, but you have the best available tools. Aggregated data can be used freely if you qualified for all the different purposes, secondary use purposes. So, how to get this passed in the parliament? They said no, this can't happen. There's way too much sensitive data available for different purposes. How we tackle this problem? Okay, we have the safe and secure environments, audited environments. Data permit authority is always responsible for anonymizing data. And then once we want to publish the results that are based on the data sets that are safe and secure environments, there's a check from the data permit authority that no identifiable data will be seen in those publications. So safe and secure environments, electronic portals, data where there's a risk that anybody can be even remotely identified only in safe and secure environments. If you want to publish results based on those data sets, the publications will be checked. So now we actually come to the AI part of the secondary use purposes. This was very difficult to get passed in the parliament. It was very difficult to explain to people. There were a lot of people against it. Development and innovation activities, and here you see the definition is as it's in the Act. By the way, the Act is translated into English, so if you're interested, it's available for you to have a look at. So that's what we meant with the development innovations. And sort of the conversation we had in Finland in the parliament, and before that, many people were against this. What we were trying to explain to many people, yes, in the GDPR, in the recital of 159, there's some sort of definition of what is scientific research. And we said that we want to enable more things, more development that's possible using conventional scientific research tools. And what we were talking about actually was using AI. And many people didn't understand that. And I didn't understand why, they don't understand why we are enabling more tools to be used. We're enabling used machine learning algorithms, data analytics to be used. And what it actually means, and we had to narrow the scope actually in the parliament, was development of new personalized medicines, personalized care, which are good things, I think. Evaluation of new products, new processes, new tools. Development of healthcare technologies, new products, new solutions. Development of the social and healthcare services or the service system. So, using those modern tools. Sure, you can use scientific research tools as well if you want to, but you're going to use AI. And it's allowed in the legislation. And so the conditions for this using AI so for development and innovation activities came, as you can see when you read that, actually from the GDPR. So in order to use all those different data sets for development innovation activities, it has to, in order to promote public health and social security, which is fine when we talk about social and healthcare services, or develop the social and healthcare services or the services system, and then you have to protect the rights of the individuals. So that sort of things came from the GDPR Article 23, and we were okay about it. So I'm not going to go through all this, but who actually benefits from this legislation? I will benefit, you will benefit, everybody will benefit from this legislation. Researchers will certainly benefit from this legislation. Enterprises will benefit from this. Lots of different people will benefit from this legislation. So here how we have derived the legal basis for the different secondary use purposes from the GDPR. That was an interesting task. I said in the beginning that you need to have all the, I was going to say that you need to have all the stakeholders actually involved when you get this sort of legislation passed. What we had involved from the start with was the Finnish Data Protection Authority and their experts. It would not have been possible to pass this sort of legislation in the Parliament without the help of the Data Protection Authority, Supervisor, the Ombudsman. And so get them involved from the start. And of course, now that the law has been passed and we have FinData, which is the Data Permit Authority, the challenge is how to make it happen in the real world. And that's what we're actually doing. And we have all the different stakeholders, all the different authorities, all the different data controllers involved, as well as the Data Protection Authority. I forgot to mention that, of course, the secondary use is, of course, logged. So logs of everything that's done for secondary use purposes actually in the future can be seen from the citizens' portals as well. Thank you.
Thank you very much. I have to say that I'm a little bit scared by the presentation. And actually, I want to ask one question. There's a number of questions that I definitely will have to ask my Finnish colleague on how the supervision of this idea looks like. But could you tell me if the FinData is a hub for the information, or this is the place where the information is stored? If this is stored, then how it looks like? Is it updated information in one central place, or this is just the place where you have the metadata on where the data can be found? So simply you are redirecting them to the place where the information is, where the data is.
FinData interlinks the information. It's not storing the information itself. There's a possibility in the legislation, or it's a demand actually, that the sort of description of the data will be stored. So if needed, the data can be
Reused? No.
Reused again and again if needed. So, for example, if somebody wants to study the same thing using the same data sets, using data descriptions, the data sets can be reformed again.
Okay, well, the concept is interesting and the implementation is interesting. Now we will have to know more about the supervision of that, how it looks like. But first we have to go to the Commission. The Commission that will say us what is their expectation towards the governance of the artificial intelligence in the future.
Thank you very much. And thank you to all the courageous people who are still there after I don't know how many panels on artificial intelligence. So, yeah, I mean, just to take, let's say, some step back, from the beginning in the Commission, I mean, the reflection has been on how to develop artificial intelligence on the basis of European values. And this has been, again, stressed very strongly by the President of the Commission in Davos. So when we published the European strategy on AI in April 2018, we had three objectives. To boost AI activities, to preparing for socio-economic changes, but one very important objective was to ensure the appropriate ethical and legal framework for AI. And this is why we had set up this high-level group, high-level expert group on AI, which came out with their guidelines and these guidelines are, in fact, to a large extent, similar also to the work which has been done in Germany with the Data Ethics Commission. There are a lot of similarities, insisting on human oversight, technical robustness, privacy, transparency, diversity, non-discrimination, fairness, societal and environmental well-being, and accountability. So the question is that when you say all these, let's say, requirements, and you look at the GDPR, it means that, in fact, the GDPR in advance, let's say, anticipated many of these requirements. As was said before, I mean, one key objective of the GDPR is to ensure, among its principles, the fairness of the processing of personal data. So we have here an horizontal legislation. Indeed, we have other principles which are also key, like the lawfulness. You need to find the proper legal base, the transparency, the accuracy, which is also there. I think it's when auditing a system, I mean, how, of course, the biased training would go against the principle of accuracy, and you have the general principle of accountability. And then the general data protection regulation, we argue in this discussion on AI, is already providing quite a number of strong instruments to ensure that fundamental rights are, let's say, upheld when developing AI system. And one of the tools is a data protection impact assessment, because as soon as you have a high risk, a potential high risk for a person, then you have to conduct this impact assessment, and this is shifting, let's say, the focus from an ex post correction to an ex ante prevention of unfair processing. And I think for AI system, this is a very, let's say, important element. I don't know, it's probably very difficult to implement, but this is something extremely important. We talked about data protection by design and by default, and this is there. Whether or not it's implemented is also something important. We have the security issue, and we have all these articles that you are all fully aware about automated decision making. And there, here, in this Article 22 on automated decision making, there is the obligation to ensure suitable measure to safeguard the individual rights and freedom. And of course, if you have a biased algorithm, then you would probably not comply with this requirement. And you have the right for meaningful information, and so on and so forth. So we have here a set of rules which have been not specifically designed for artificial intelligence, but if you look at also the work of the German Ethics Commission, I mean, the various elements are there to ensure that the inaccuracies in personal data, the bias are basically taken into account to avoid this discriminatory effect. Now the question is indeed how to deal with the complexity and opacity of the AI system, and this is what was mentioned beforehand, that indeed it's not only for the data protection authorities, it's for the data protection officer, it's ultimately also for the court if a case is brought to the court. So the question is not to come with new laws or new rules for data protection aspect, but how to enforce these new rules. And what is very important also in this context is that the GDPR does not make only efficient, let's say, data protection, but also other fundamental rights altogether. And as you know, in the EU, we have a whole body of legislation. We have anti-discrimination, freedom of expression, gender equality, etc. But you can speak about asylum, migration, cooperation in criminal matter, financial services, etc. So when you, as a DPA, and this is a challenging task, implement this principle, how to relate possibly to other bodies, to other actors in the society to implement this principle. For instance, if we talk about fairness or non-discrimination, you have a difference between a group. You can be, let's say, unfair vis-à-vis one person and fair vis-à-vis a group. You can have a positive discrimination because you want to rebalance, let's say, the number of female managers in an organization, for instance. So indeed, you will have it might be unfair seen in isolation to one individual case, which is often what GDPR is about, but as a group, then of course the policy would be fair. So you need to conduct this in context assessment. So this is also a challenge for the DPAs. So how to overcome these challenges? I think, this is something which has been mentioned already by the previous speakers, probably is to develop cooperation with other bodies, with, for instance, non-discrimination bodies, who do not have, like the DPAs, the big powers that the GDPR gave to them. So probably the DPAs can help there because you have the big guns. And voila. And then the question is to make use of them, of course, and we strongly encourage them to make use of them. And then also to develop what we call this explainability, auditability, and this was mentioned, you mentioned the auditability in the different phases, how to really be able to, not to explain, but maybe to document the development of an AI system. And it was mentioned also very clearly before that it's not off-the-shelf systems. You take a system, it's progressively developed by different participants in the chain. So how to document, how to be able to assess a system, especially if it's a black box and you cannot maybe come with an intelligible explanation of the rationale, but to document the effects. So this is, I think, a very important element that we have to reflect in the future. So in a nutshell, we have the legislation for AI for the data protection aspect. I'm not speaking about the other element, but for the data protection aspect, we have a legislation in place. The question for the governance and for the role of the DPAs is really now how to figure out, I think, these two elements of working on this, assessing the fairness in the broad sense, and the auditability to have a very practical approach. Thank you very much.
Okay, before we start with the questions from the audience, let me ask two short questions to you. The first one, building on what Olivier said just a while ago, do we think that we need the tools for the supervisory authorities that are not accessible now? But building on your experience in supervision, Marit, can you tell us that there are some organizational tools, but also the software probably, or the software solutions, or the technical tools that you would need to do the same work that you do the last 10 years now for the artificial intelligence systems?
So artificial intelligence systems is, of course, a big term, and
Yes.
almost everything can be part of the broad definition. And therefore, neural networks, for example, are a different thing than other machine learning parts. And so probably, yes, we need more tools, also technical tools, or a mixture of.
Is there a market for that?
Sorry?
Is there a market for that?
Are there people who have some ideas where, because some part is if we have black boxes, what about black box testing? And I think there are already some tools, like reverse engineering tools, where we try to understand something, but it's not necessarily something where this is how we want to do it. It could be like testing tools, which also be used, by the way. Why is it only something for DPAs? I think it's already something for the developers who have to check their systems already, or the controllers who want to buy or use the systems. They also have to do the checks. So usually this is not something so special with us, unless this is some like, if we want the cooperative tools for checking law enforcement parts on the European level, then I think we need some new tools. Otherwise, the same tools should be already be in place or available. Probably they are not, especially because the development has not taken into account, because very often, if you have a compliant development already, then it's clear that you have intermediary results where we can do the checking or check already if there's a bias or not. But tools, for example, to know that there's a biased system, this is so difficult. Otherwise, if we have defined or generated test sets and know the outcome and see whether it's like the elephant in the kitchen problem, that it's totally different, this can be checked.
Okay, Ruben, and you have you dealt with the problem of the black box. Do you think that we are ready to approach it as the data protection authorities at the moment, or we need the expertise and we need the tools as well to fight with the problem of the black box?
Yeah, I think there are a lot of different ways that you can explain and things that you might need to explain rather than just the relationship between the inputs and the outputs. So there's all of the design considerations There's what kinds of accuracy have you tested for? How have you traded off false positives and false negatives? Those are decisions that need to be justified. And you can do all of that without breaking open the black box. At the same time, many of the so-called black box applications, the advantages of using a black box model versus using a simpler linear model are often very small. So the trade-off that we're posed with is often a false one, or the gains in accuracy are so marginal that it wouldn't be worth it. In terms of whether DPAs have the tools, I think these are tests that we should be expecting data controllers to document and justify. In extreme cases, we may need to check them independently ourselves, and then we'll need particular expertise and particular tools as well.
Okay, Joni.
Well, DPAs, at least in Finland, don't have the tools, they don't have the resources. And what they actually lack as well in Finland at the moment seems to be that they have no technical experts, or they have one technical expert. So we try to tackle that in the legislation as well, enabling legislation that it would be possible to build those tools for DPAs as well, if that's what is wanted. And it seems to be the case that that's one thing we could actually build, if that's the case, but it's only one solution to build sort of tools for DPAs. I would actually see that it's a cooperation with DPAs and all the different authorities. Our solution was the central data permit authority would try to sort of tackle the use of AI. It doesn't work that there's only one authority. There's actually lots of expert groups that's monitoring the use of using AI. And I'm actually the chair of one of the technical groups as well. So there's lots of expertise, lots of different kinds of expertise you actually need.
So the cooperation definitely one of the tools, and I hope, Mari, that you will be able, with your knowledge, to check the systems like the one in Finland, for example, as a part of cooperation between the data protection authorities. Okay, I open the floor to the questions. Yes, please, if you can go to the microphone.
Antonio Kung, I am responsible for ISO for a study on the impact of AI on privacy. So AI governance is very important, and the description of the panel said which form of AI governance we should have. And my question is also who is governing, and how can we identify in the ecosystem who is governing? I give an example. If you have an autonomous vehicle, maybe the programmer decided something, which is the policy which actually the AI system is doing, to make a decision when there's an accident, okay? So the problem that we have to have is not only to describe who is the data controller, data processor, but which form and who is governing. So my question is whether we should take that on board in our discussions.
Okay, thank you. Some other question at the moment? Yes, please.
Good evening. Thanks for the very enlightening presentations. My name is Oscar Steim. I'm assistant professor at the University of Groningen in the Netherlands. And so far, I think, at least from my perception, you talked a lot about procedures and certification mechanisms. But I'm wondering whether and to which degree you see also the necessity to have more substantive discussions in the sense, what does fairness mean, what does transparency mean? And the background why I'm asking this question is because also within the European Union, there is maybe the question, how much flexibility do member states want? Is it good to have differences, or should we all have the same kind of substantive concept? So I'm very interested in hearing about your views on that. Thank you.
Is there anybody of the panelists who wants to answer? Yeah, please, Robin.
I'm not sure if this will exactly answer the questions about fairness and transparency, but just to speak on the note about member states having potentially different approaches to things. One of the things that we discovered or we developed during the Sandbox is to test whether an AI system is discriminatory. You very often will need data that has labels of the protected characteristics. gender, race, religion, etc. And so there's a question of what legal basis do you use to process that? And one of the things we looked at was in the Data Protection Act in the UK, there is a provision in Schedule 1 which says that one of the Article 9 grounds can be where it needs to be supplemented, so the substantial public interest ground, where it needs to be supplemented, it can be supplemented by there's a provision on equality of opportunity monitoring in the UK Data Protection Act. And so we looked at whether that would be a potential Article 9 basis for doing that kind of analysis to assess the discrimination effects of a system using special category data. And I'm not sure to what extent those similar provisions exist in other member states.
Right.
Yeah, we really have a problem also as a data protection authority if we want to issue a fine based on now this was unfair or this was not transparent. This probably is not enough for a court. They really want to know how much they should, how much the data controllers should provide. Is this now on this side, on the other side of a red line? So this is not always easy, especially because there has been court rulings, of course, already on what about scoring algorithms? Do they have to be published? Is this already meaningful information? What about the logic? Is it now something where it has to be revealed or not? And in Germany, we had a court ruling saying, the data subject is not allowed to get, or that is not isn't to be informed about everything there because of the business secrets. And this may be revised, perhaps, but it's also, does it make sense to issue all the code or all the neural network states or some? Perhaps they can be easily provided, but is it meaningful? Not for anybody. So probably there have to be the realistic and the practical cases where it's clear how it will work, or whether it's sometimes the input-output stability, robustness, and so. The same for fairness, the same for transparency, the same for also accuracy. Also about if we want to find a bias, but we delete beforehand all the sensitive information, then especially we cannot find so much discrimination stuff because we don't know whether people are female or male or handicapped or not or so, because this is already data minimized. So in some stages of the development we probably need some sensitive information to be sure that later on we don't have sensitive effects. This is also something very interesting. And the last thing on what about the programmers? I heard from some professors in the criminal code research, they say, yes, the programmers, they have decided. And if they have not decided, they have decided not to decide, so they have decided. And it's their fault. And the criminal system will immediately stop them programming wrong autonomous car driving or so. I think this is heavily unfair. Of course, they need a specification. Somebody is responsible for a specification. And otherwise, I could not recommend any job in this area if it's totally clear the programmers, it's their fault. No, it should be clear, it should be documented, and for the data protection authorities, it's clear we talk to the data controller, and the data controller very often is not about the own employees, but about the bought software or hired data processors or so. And it's not down only to the programmers, but the programmers should also know, and the developers as such, so the architects of the system, where are interesting sweet spots to decide something. Where is it about data minimization and in which phase? Or can they decide something? Should they document something if they find out about some discrimination? Should they keep their mouths shut or should they do something? And there I also see some technical help where it's clear for a milestone that first the DPO in the company, also in programmers companies, can have a check, or when do we need an ethical board, or when do we need stakeholders from also the employee associations and so on. And right now it's more, everybody's very quick in doing, and nobody wants to have the fault for some wrongdoing. I think this is a bad system and the wrong incidents are there.
Okay, one more question to Ruben. Is there a limit for sandboxes? Are there the things that you would not allow to test in the sandbox?
Do you mean if someone applies
Yes.
and they want to do something and
Yes,
we're
and you
we're
say
fairly
no,
confident?
it's not even not for the sandbox. We don't believe that it can work, and we are not going to deal with it.
Yeah, we had a lot of applications, and some of the ones we had to turn down were ones where we thought there's a good chance that this will not be able to be done in a compliant way.
Okay. Do we have any other questions at the moment? If not, of course, the speakers are accessible also after the session. But I would like to ask you for the brief conclusion, but just a minute of the, as I usually say, the tweet that you want to leave after the session. Olivier, maybe starting from you now.
Well, I will not repeat what I have said before, but I think that one key element, and I think that at least 2 persons on this panel will agree with me on that, is that now that we have this responsibility, this general responsibility on DPAs to ensure fairness in complex systems like algorithmic system or artificial intelligence system, one key element is to have the necessary expertise and resource for the data protection authorities. And we see there is a wide variety of level of resources among data protection authorities. And now, more than ever, with this development, we need to ensure to have not only the human, the financial, but also the technical capacity of data protection authorities. Otherwise, the powers that was granted to them, in fact, will not be exercised. And this would be a very bad conclusion for the GDPR, I would say.
Joni.
Thank you. Yeah, like I said in the beginning, get all the stakeholders involved right from the start. If you do regulations regarding this area, have it public since the beginning. Get everybody involved. Cooperation is the key. Yes, we have sandboxes in a way. What is the Finnish legislation where the data permit authority operates? Yes, we have a sandbox where AI is working in. That could be one solution. What's happening at the moment, the legislation is lagging behind all the time. We have more and more technical tools. So I would be happy that we would keep up with the legislation, but cooperation is the key in order to have all the different authorities monitoring what's actually happening in the real world. Thank you.
Marit.
I think I agree that the technical resources and also other disciplines, because even technical people don't know much about discrimination. So many ideas, many disciplines have to work together. Right now, the culture in a DPA, and because of all the requests and complaints and so on, is not in the right way, I think, to promote that. So if you hire technical people, then probably they feel alone. If there's nothing where they can exchange their views. Or we have heard we need specialists, so many, and the specialists in a public service sometimes are very specialists on their very single spot, but not perhaps can grow as on another market. So probably the culture change there means cooperation with many more, some spaces, some labs, some perhaps ways where information can be gathered in a better way, and I think we don't have the right formats for that right now, especially because technical people, if they have some knowledge in AI, they get much more payment if they are hired by Google than if I'm able to hire them. So this is also something the culture right now plays against the expertise at DPAs.
Ruben.
Yeah, I think if there's a message I had to send out, it would be I think the level of expertise that is really needed is the ability to ask questions that cut through obfuscation when data scientists, machine learning engineers talk about their systems to non-experts. I think that we need to get to the situation where people know enough that they can ask difficult questions. And so to that end, one of the things I'm doing in the ICO is I'm running a course, AI 101. We'll get hands on with building toy example systems. and also just a range of training across the organization so that right down from people who are answering the phone of a complaint to the people investigating can actually ask those difficult questions.
Thank you very much. Thank you, everybody. Just at the end, I would like to say that it's not true that there are only lawyers in data protection authorities. More and more commissioners, more and more heads of the data protection authorities are non-lawyers. At the moment, we are in a situation where the heads of authority in Germany, UK, Ireland, as far as I know, Poland, even Italy, these are the people who don't have the legal background. They come from the other fields. Thank you for patience, and I think the bar is open right now. So we invite you to La Village for the cocktail.